number 87, the people of the state of New York versus Victor Thomas. Counsel?
Thank you, Your Honor, and good afternoon, Your Honors. May it please the Court, Louis O'Neill for Mr. Thomas, and I respectfully request 1 minute for rebuttal. Your Honors, both waivers in this case, the written waiver and the oral waiver, are invalid for different reasons. The written waiver is invalid as violative of public policy, whereas the oral waiver is kind of a greatest hits of everything you're not supposed to do during an oral colloquy to obtain a waiver. The courts of this state have enunciated a group of rights that can never be waived, and therefore this court cannot allow a no notice of appeal waiver that waives any judicial check.
But what's the practical difference between saying that and saying you don't have a right to appeal, which we've said isn't true? You can appeal, for example, constitutional speedy trial, right? And saying, okay, you have no right to appeal. And we say, of course, you still have these rights. And what you've waived is what's waivable. What's the substantive difference between that and saying you can't file a notice of appeal?
It's an enormous difference, Your Honor, and that's that it strips the court of its subject matter jurisdiction. The no notice of appeal waiver removes all jurisdiction from the court to review anything that might survive that would be unwaivable.
Let's say I had a constitutional speedy trial claim, and I have that provision in my waiver, and I don't file. Is there any relief?
Well, in that case, if you don't file your notice of, if you've lost your jurisdiction, the court has no jurisdiction.
And the court can never hear my constitutional speedy trial claim?
No, because you've waived the jurisdiction of the court.
How is that different from waiving any other right to seek relief in a court? We've said, as long as it's knowing, voluntary, and intelligent, you can waive all sorts of rights. You can waive constitutional rights. And so I'm not sure I understand the argument that it's depriving the court. The court still has jurisdiction, but you've waived your right to ask the court to exercise that jurisdiction.
As a practical matter, the court can never hear those unwaivable things because the mechanism of the appeal is such that once the notice is filed, then the record gets created, the appellate lawyer gets assigned.
But isn't the core of it, first off, two things. There's a difference between the oral and the written waiver and also the perception of the person who's having an admonition from the court is different than a written waiver that's prepared, say, by the DA's office, and they have to sign and then it's made part of the record. Would you say that there's a difference between the two?
Absolutely, and we can highlight that in this case.
And here, the oral waiver, of course, was good. So let me just finish. Let's assume that we think the oral waiver didn't cover anything, but there wasn't affirmatively incorrect information given as there was in the written waiver. In the written waiver, there was affirmatively incorrect information. So you got two problems. What's the source of the waiver? And secondly, is there a distinction to be drawn from information that the court fails to give you that you're getting somewhere else? Or if the court gives you affirmatively incorrect information, because then it affects what you know and how you would evaluate it.
Exactly, Your Honor, and that's what happened here, because the no notice of appeal waiver tells the appellant, you can't appeal anything, when in fact that is not true. That is a misstatement.
Well, hold on a second. Let's focus on the language of the written waiver. Waives any and all rights to appeal, including the right to file a notice of appeal from the judgment of conviction herein, comma, with the exception of any constitutional speedy trial claim, which may have been advanced, the legality of the sentence, my competency to stand trial, and the voluntariness of this plea and waiver.
Those are the four Seaberg traditional waivers, but those are not written in stone. The law is dynamic and evolving, and we've identified at least 20 things.
So your position is that that doesn't alert the person signing this that there are things that survive?
The contrary, it alerts him that it's in black and white. Only these four things survive, when in fact, courts of the state have found at least 20 different items not covered by the four Seaberg waivers that survive.
So what's the remedy?
The remedy is to, the appellate court, the appellate divisions need this court's guidance with a bright line rule. If the no notice of appeal waiver language appears.
So are you mandating a particular, are you asking for, and I don't mean mandating, are you asking for a particular colloquy that we would?
No, certainly not. That is not this court's jurisprudence, not the state's practice at all.
What if the waiver said you waive the right to file a notice of appeal except for claims that are non-waivable? What if you just said that?
Well, that's better, but it's not, again, giving, these rights are so important.
Why is that
we need-
not good enough?
Because these rights are so important that we need a bright line guidance that discouraging appeals, well, let's even get deeper. The Supreme Court has just.
You're not arguing, somewhat apropos to what Judge
Well-
Fahey is asking about. You're not arguing that at some point, whether it's the written waiver or in the oral colloquy, anybody has to go through at least all the types of claims that have so far been identified as non-waivable. You're not taking that position.
No, the Supreme Court has just last year in Garza versus Idaho said it is per se ineffectiveness not to file a notice of waiver of appeal. And that is not some ministerial task. That is, the reason that the court used the word ministerial in that case is to show how simple it is. You got to do this. If you don't do that, you violated the Sixth Amendment, and you are per se ineffective. Of course, the court needs to have a bright line rule that if this language is in the waiver, the whole thing is void. Turning to the oral waiver, as I mentioned, this is kind of a greatest hits of all the mistakes you don't want to make. The oral waiver happened after the allocution and the plea. I would draw the court's attention to page A90 of the record. This began at 11:55 a.m. The people said, this offer is on the table today only. The system had lost a defendant. They found him at 11:55, right before lunch, and they rushed through the process. It couldn't have been, the court delegated the explanation of the waiver to defense counsel and elicited yes, sir answers, one-word answers that this court has found to be part of a problematic colloquy. More importantly, this waiver, the court specifically carved out the suppression hearing. It said, and I quote, "This waiver covers the plea we're doing today and the sentence that'll take place in 2 weeks." It didn't use the word conviction, which we've seen in Sanders and Bryan and other cases. It used the word plea, and it didn't use the word judgment, which could be subject to debate. It said plea and sentence. It carved out the suppression hearing. And that's why there was no protest from the defendant or defense counsel, because he was told by the judge, it's carved out. The notion.
Complete your
I see
sentence.
my time has expired already, Your Honor. May I briefly address the third issue? There is no record evidence that this interaction between the police and defendant was anything but the functional equivalent of an interrogation. The picture, the photograph alone, showing the defendant dispositive.
Let me ask you this. If when the defendant first asked, what am I being arrested for? If they had answered that question, the officer's arresting him, is that an interrogation?
No. If they'd answered immediately.
Why is it an interrogation later?
Because we've got to look at the interrogation environment, which is not 1 minute, as the people will focus on. It's 15, 20 minutes in 3 different locations.
Yeah, but he's constantly asking for that information. So they
And-
finally supply it. Why is it an
Upon
interrogation?
upon arrest,
Yes.
Detective Rodriguez said, they want to talk to you. Detective wants to talk to you. Miranda triggers then, and it was never given. Then they called ahead, saying, Detective Gross, we've got him, he's coming. And then at the station, Detective Gross, breaking protocol, comes down with the photograph within 1 minute and says, we're going to talk about this with the dispositive inculpatory evidence. There is no record view other than this is an interrogation. Thank you, Your Honors.
Thank you, counsel. Counsel?
Thank you. Good afternoon, Your Honors, and may it please the Court. Justin Braun for the Office of Darcell D. Clark. If I may get to the last point first, before the waiver. This Court can't reach the question because it's a mixed question of law and fact. Rivers is right on point about that, and it must affirm unless there is no possible view of the evidence that would support the conclusion reached by both the Appellate Division and the Suppression Court in this case with regard to Huntley. But here there is, of course, a lot of evidence. This was a very belligerent defendant. There was no breaking of protocol whatsoever in this case, because what happened was he was taken to the front desk. There was not going to be any sort of extensive interview there, but because he was so belligerent and possibly endangering the officers and the other arrestees, they had to do something to try to get this under control. And in this case, they showed him the photograph. They showed him the photograph without any intention.
What did the officer say when he showed him the photograph?
He, as far as I can tell, if I have my memory serves, he said, this is why you're here. He showed him the photograph, which we have.
He didn't say, I want to talk to you about this?
No.
He didn't say, we're going to discuss this?
As far as I remember, no. And we have legion, because this deals with federal case law.
Why is he not given his Miranda rights? Why is he not informed at the point of his arrest?
Well, he wasn't informed at the point of his arrest because in that particular case, he was, the officer that went to go get him was
No,
not the
why
detective.
don't they give him his Miranda rights when they cuff him?
Because that wouldn't have been proper protocol. The protocol was to interview him at the precinct in an interview room under those sorts of situations. So the officer.
It's not proper to tell him you don't have to choose to speak to anyone in the ride down? You don't have to keep asking questions?
Well, again, in this, the case law of this case has been very clear that there's no requirement that you have to Mirandize at the scene of arrest. And furthermore, we've had legion cases that have said where they're asking, you know, nothing's being said, but they're asking, you're allowed to provide an innocuous answer. You're even allowed to say, we're going to talk to you about it at the correct time and place, which is what happened in
Well,
this
we'd like
case.
to talk to you about it.
Correct. Yes.
So,
If they invoke their rights, you're not going to be talking to them about it.
Correct. Yes. And because this is Miranda, it's federal case law, and the federal case law on this is pretty clear that an innocuous showing of evidence, particularly where there's exigent circumstances like this, is not a violation of the rights.
But here is the officer in part saying that they're not answering the question because of, he knows him, he knows how he reacts, this kind of thing? And
Quite
is
the
that part of
opposite.
not giving him the Miranda?
Quite the opposite. This officer would not have wanted to wound him up. He already had a physical altercation with him. The defense theory doesn't make sense that he was conspiring with the other officers to find the perfect avenue by which he would make this sort of inculpatory statement with this confluence of events. It just doesn't make sense.
so we of course don't reach that issue if we uphold the waiver.
Correct.
All right, so why is the waiver valid here?
Okay, the waiver is valid here for a number of reasons. Here, the no notice of appeal waiver was obviously discussed in a way that showed that some rights survive. Some appellate rights survive, even a waiver of appeal. And suppression wasn't one of them. So in this particular case, it was entirely clear that the suppression was not going to
The
survive.
problem is what I asked counsel before. It seems that the language that was used actively gave incorrect information. Would you agree with that?
I would not agree with that.
I would
Because
say all the information in this waiver was correct.
I don't think this waiver has problematic language in the sense that it says you're waiving your right.
Let me just stop you. You won't be able to hire an attorney to file appeal for you. You won't get an assigned attorney to file appeal for you. You won't be able to file your own appeal. You won't get waiving fees. There's just going to be no review by any court. Oh, no, that's from Green.
Yeah, I'm
The
sorry. I
language
think
is
we're
saying,
looking at a different
yeah.
waiver.
It seemed like all of the active language that was wrong in this one were all in the written waiver, and I'm wondering if a distinction needs to be drawn between the written waiver and the oral waiver that the judge gives.
Well, yes, and this court has held numerous times that the combination.
So would we be saying, let's assume that I'm correct, that the written waiver was overbroad. If we affirm, we'd be saying as long as the judge doesn't give actively incorrect information, that the waiver will stand?
Well, yes, I mean, we have case law that specifically says where there's an ambiguous or problematic waiver, the combination of the oral
I
and.
don't remember in this one, this is Thomas, did your office prepare the waiver?
Our office did prepare this waiver, yes. But what I would say is, again, as your honors have pointed out, the filing of a notice of appeal is the mechanism by which a defendant relinquishes his right to appeal. It's a statutory mechanism. It's not the same as a fundamental constitutional right, even though you have, obviously, you can waive certain constitutional rights as well, but you have 30 days under statute to file the notice. And under Garza, that's.
So what did the people gain from that part of the waiver, to waive my right to file a notice of appeal?
Well, to be honest, we found in practice that we didn't gain anything, which is why we don't use it
Is that why you no
anymore.
longer use it?
Yes.
Yes. So if you didn't gain anything, means he can't really promise you anything, then how is it valid?
Well, it's.
Right? That the contractual agreement, there has to be something you're
Right.
giving up or getting, right?
Well, I mean, in the sense, we didn't gain anything in the sense that it didn't make a material difference in our appeals, because just like in this appeal, people were filing their appeals anyway, and people were getting their claims heard anyway. But it is a waivable right. It is a consideration. It is something that we decided over time it wasn't worth it anymore to have the lawyers. By the way,
I guess my question was, and I thought you had said the answer to this is no. My question was whether or not you have any recourse for the breach of this promise.
No, we don't, not in this
don't.
particular case.
You don't.
So, yes, we don't, which is why this is not coercive. And by the way, it also does.
I'm just saying, how could it be a valid agreement?
Well, I mean, if Your Honors want to say that that particular clause needs to be excised for that reason, that's possible, but it is a statutory right that can be
But
waived.
maybe I'm missing something here, but don't you gain the benefit of not having to deal with an appeal?
That's the hope, yes. Yes.
Seems like a big benefit.
And whereas
No, but my point is that's always true with a waiver. That is the point of the waiver. But you can't stop them, and you're telling me you have no recourse if they actually file a notice. You have recourse if they file, right, an appeal, and they are trying to get a merits review of claims that they have actually waived, as opposed to the non-waivable.
I think it's a
grounds.
distinction without a difference, because either way, we have to answer
means
their
something
claims.
to
Well,
them, no?
either way, we have to, if I may make
Please.
quick point. There's no divestment of jurisdiction here by the failure to file a notice of appeal. That's clear from Seaberg, which rejects that any jurisdiction is infringed by waiver, and again by Lopez, that you're always free to waive your rights as a relinquishment. And then I would also just point out, just as a last thing, this was a negotiated, freely bargained plea.
Can I just ask
Yes.
you, can we invalidate this particular waiver without overruling Ramos?
Can you invalidate, in what way, Your Honor? I'm not sure I follow.
Ramos seemed to indicate that if you said things that were overbroad, that didn't invalidate the entire.
Yes, I mean,
Right.
as I'm sorry, I don't mean to interrupt, but as I discussed earlier, because it speaks in quasi-contract, because Garza says it speaks in quasi-contract, because Garza says this is a purely ministerial act, yes, it is possible to excise a clause like that.
Thank you,
Thank you.
counsel. Counsel?
Thank you, Your Honor. A few quick points. The
So
people.
why can't we just do that? Let's say we agree with you on the part that refers to the notice of appeal, but disagree otherwise. Can we just excise it? Why does entire waiver?
I'll answer both your questions at once, because if this no notice of appeal language were not in this particular waiver,
Yeah.
it's the waiver we've seen a million times. It's a normal waiver that's been accepted many times. The point is different, that there has to be a bright line rule that this language invalidates the entire waiver, because it's hoodwinking appellants. It's hoodwinking
In
dependents.
what way, though, if the focus is on, and always has been on in our cases in this area, voluntary, knowing, how does this change that analysis because you have this phrase in there?
How can you explain to a defendant that facing serious time, that you're going to avoid your Sixth Amendment obligations to file a notice of appeal, which is required to be done?
But if you have a right to appeal, which is laid out in that waiver form, constitutional speedy trial, doesn't that give you the idea that you have to file a notice of appeal to do that?
No, Your Honor, because it's giving false information, because there are 20 and more things that can never be waived under this state's jurisprudence.
Well, one, the 20 or more things kind of counsels against any kind of litany. But to Judge Stein's point, in the past, where we have had an overbroad provision, where we've said you waived everything, no court will ever hear anything, we've said that's a valid waiver because you knew what you were waiving. You thought you were waiving everything, but you were waiving certain appellate rights. And to the extent that's overbroad, we're not going to enforce it. What's the difference here?
Difference is here
Wouldn't
there's-
we have to change the way we approach waivers?
Absolutely not. Absolutely not, Your Honor. This is here we have a situational coercion situation. The defendant had no understanding of what this could possibly mean, either in the written waiver, which was never explained by the judge, so the judge delegated that, and in the oral colloquy. There was absolutely no understanding what this could mean for those other rights that survive besides the Seaberg Four, as we'll call them.
Thank you, counsel. With respect to the next two appeals on the calendar, 88 and 89, People versus Nicole Green and People versus Storm Lang, we'll hear from each of the appellants, and then we'll hear from the respondent. Thank you, counsel.
Good afternoon, Your Honors. James Special for Miss Green. Can I reserve 1 minute of my time,
1 minute,
please?
sir?
Yes, please.
You may, of course.
Thank you. I will actually start with something that Judge Fahey had
Good
touched on.
place to start, Mr. Special. It's always a good place to start. There you go.
Well, you actually read the part of the colloquy.
I read yours instead of his.
Yeah.
No, that's right. It's
So-
not the only mistake I've made in my life. But
For me, it's great. So here, in both the colloquy and the written waiver, there's things that are just plain wrong, and there's things that are contradictory. At one time, county court said there's going to flat out be no review by any other court.
So is that different when we start talking about, Lopez talked about mischaracterization of the right to appeal. Is that different from just being overbroad?
Yes, Judge.
Okay, and how is it different, and how does it apply here? Is it the fact that it's talking about review, like 440 review and habeas review, which I don't think is considered part of what we generally think of as the right to appeal to a higher court, right? So is that the distinction, or what is it?
I think the key here is that it's not just overbroad. It's that it's logically inconsistent. The waiver, there are statements that are made that are just incompatible with other statements that are made. For instance, in the written waiver, at the top it says, can't file a brief, can't have counsel. And then at the bottom it says, oh, wait, there's some things that you can bring up in a brief. So on the same page, it says you can do this, but you can't do that.
But how is that different from saying you can't file a notice of appeal, but there are certain, and now I'm sort of talking about the previous case, but there are certain things that are excluded from that?
Well,
That's inconsistent too. Do you think that falls into the same category?
I think that it's similar. What I would say is here, there's even more than one statement that's wrong and incompatible with other statements.
You know what I'm wondering, and this is kind of a question everybody that comes up, is there a difference between a judge not leaving something out, because judges may leave something out, but whether a judge actively gives wrong information or incorrect legal advice from a judge doing it than a written waiver giving incorrect legal advice?
Well, Judge, I think that coming from a judge is certainly hurts.
This waiver, I'm assuming this was also drafted by the district attorney's office?
Yes.
Okay.
As far as
so the district attorney will address that, but that's as far as the written waiver goes. But as far as the language over a judge, you have no control over that.
Right.
Right. Okay.
Right. And on...
What's the difference? How would you address the public policy concern, or is there even a public policy concern about a trial court giving, I don't think it's an active negligent act on a judge's part, but misleading information, making a mistake.
Oh, sorry.
Yeah, just like making a mistake, just like I did. I read the wrong thing. Right. Now, reading the wrong thing, if that was one of your fundamental rights, would that vitiate your right?
Yes, and I also think here,
well, why is that? Because it goes to what Judge Garcia was asking. Does it affect the nature of what you know, whether your plea was knowing, intelligent, or voluntary?
Well, do you mean whether the plea was or the waiver was?
The waiver.
Sorry, okay, yeah, so I think it does, because here, you would have to say, okay, well, the judge is saying things that are different and making all of these misstatements that are inconsistent with each other. So I don't see how anyone in Ms. Green's shoes could say, okay, well, I understand what I'm giving up.
Well, you mean it affects what you know?
What you knowing, intelligent, and voluntary. And also, I would say here that when county court says you can't get counsel, for instance, well, county court is also the same court that signs us to these cases. So they're telling people, oh no, you can't get counsel, when in fact they can.
Would any lawyer tell their client that? I mean, there's a colloquy in most of these, and I don't remember in this particular one, But have you discussed the written waiver with your counsel, right? And I think on some of the forms it says, I've discussed this with my lawyer.
Right.
Would a lawyer say to them, you may have a right to constitutional speedy trial claim, but, I can't represent you? Would that be competent advice?
If the lawyer said that you can challenge that on appeal via
If you
speedy
bring an
trial?
appeal, I can't represent you because you just waived the fact that you can have a lawyer, so good luck with it. But we just waived that. Is that competent advice by a lawyer?
No, if you're telling them that they're waiving something that they can't waive.
And they are saying in these written waivers that they've discussed the terms with their lawyers, and I think in some at least they confirm that in court, right?
Well, they confirm it that it says that the defendant had signed it. There's no talk of whether they really read it or understood what they mean, other than the judge said, well, have you looked at this with counsel? Yes. There's one word, yes, sir.
Well, it says I signed this after having it explained by the court and by my attorney, and the attorney signs it and the defendant signs it.
Right. Well, I think it would be great if we could count on counsel to tell their clients the right things all the time and flesh out these waivers and have them say this is right, this is wrong, but we can't, I don't think, just given their imperfections.
I thought in part your argument was about the judge's duty.
Right.
We don't have an ineffective assistance of counsel
Right.
claim. The point is, what's the judge's
Right.
duty? So what's, in your mind, the rule for what's the judge's duty? It in part sounded like you were suggesting perhaps saying less, not more. Is that the position you're taking? To avoid the misrepresentation problem that Judge Fahey just mentioned.
Well, while I would like a bright line rule that any misrepresentation is wrong, I don't think in this case you need to go that far, because this one has so many things that are wrong with it in the colloquy and the waiver, as far as where the judge says there's no review by any other court, and in the written waiver can't file
And in
a
part, are
brief.
you arguing that there's no way, whatever the lawyer might have said, that would overcome these inconsistencies, this confusion?
No, and I think that's the case due to the fact that that there has to be evidence on the face of the record that the waiver was made knowing and intelligently. And here, just saying, well, we've talked about this with counsel, yes, Ms. Green says yes. I mean, that doesn't really go into depth if she read the waiver, if she understood what she was reading, which is why I think we need the court to make sure, because what the court says is really what's going to end up being on the record for the most part. But I see
Thank
my
you,
time's
counsel.
up.
Thank you.
Thank you very much.
Counsel, with respect to Storm Lang, defendant?
Thank you. May it please the court, may I also reserve 1 minute for rebuttal?
You may.
First, the integrity of the system cannot withstand an assault by judges intentionally misrepresenting to indigent defendants fees will not be waived, counsel will not be appointed. And second, the language of CPL 195.20 is clear and unambiguous, and if this court were to allow the information that is required in that statute to appear in a form that is not executed by the defendant, the legislative policy
Let's go to your
would be
first
completely-
point, counsel. So really what you're asking us for is kind of a rule of deterrence, right? A punitive rule. There was, in your view, an intent to mislead here, and we should have a bright line rule, per se rule, that those waivers are invalid.
Absolutely, Your Honor. Clearly, this was an intentional act by...
Why do you say it's intentional? Because it's used in more than one colloquy? Is that what you're saying?
It's used in more than one colloquy, and he not only...
Let's just stay with the oral waiver, not the written waiver, okay? go ahead with because the oral waiver is the judge's waiver. So let's assume for now, I'm more concerned about the judge than any judge than particularly the written waiver. Okay, go ahead.
Okay, yeah, because he embraces all of the affirmative misrepresentations in the written waiver. And it's incumbent upon the court, not defense counsel, to make a record that the waiver is knowingly, intelligently, and validly made. And not all defendants are savvy, and not all defense counsels are competent and diligent.
So should we look at the defendant's background?
Absolutely, as we always have. And
So
Mr.
not a
Lang-
per se rule, but it would be misconduct plus a defendant's background?
Certainly with Mr. Lang's background, an 18-year-old. However, if a judge is routinely saying to defendants, you cannot have fees waived, you cannot have
But I think you
counsel
have to
appointed.
really choose, right? Are we going to have a per se rule, or are we going to have a sometimes per se rule if it's an 18-year-old, or are we going to have
I say
a...
per se rule, especially with the way that this language in the court, who is
And what is the most egregious language here, do you think?
saying to indigent defendants, you will not have fees waived, you will not have counsel appointed, you have no hope.
So it's that part of the written waiver, essentially.
Yes, Your Honor, I would say so. Getting back to the 195.20,
So why should the requirements for stating the time in a waiver of indictment be more onerous than the requirements for the indictment itself?
because that is the law. First,
So let's assume that the legislature meant that to be what it is, right? What makes it jurisdictional? And that, let's just assume that it was wrong, but why is it jurisdictional?
well, we cannot begin, first of all, it remains for the legislature to rewrite the law. But secondly, we
But there
cannot.
are a lot of statutory requirements that don't render something jurisdictionally invalid.
This is not an individual right, it's a public right, and a waiver of indictment actually does divest the court completely of its jurisdiction to go forward.
Some of the courts seem to be applying some distinction between when the time was knowable, was known or knowable. If there's that distinction, how can it be jurisdictional when it's knowable and not jurisdictional when it's not?
Well, all of this court's precedent requires strict adherence. It doesn't talk about knowable or unknowable. First of all, you would have to go against all of your precedent. But secondly, there's always between, on, or about. That's all the way throughout all pleadings. You can always have an approximate time, is what it calls for, between, on, or about such and such time.
What if you're talking about a 3-month-old victim? How would you allege the time? What if it was somehow discovered at some point through a medical examination and there wasn't a way to pinpoint the time? You could pinpoint days or whatever that the person had access to the child or whatever it may be, but there just wouldn't be any way to accurately allege a time. So then what happens?
I would say that, Your Honor, that the court is obligated to give effect to the plain words of the meanings that the legislature has put into this statute, firstly. Secondly,
Does your argument turn on the time, or I thought you were also arguing that the waiver didn't include the dates and places?
right, it doesn't include date, time, or place. And if we start parsing out, okay,
Well, let's say this. Here's the problem there. If we apply the single document rule, if that's being applied tonight, don't you take care of the date and place? We're really left with the time question.
no, because the defendant does not have to execute the only thing in front of the defendant waiving this fundamental right that they have to execute and puts in front of the defendant what right I am waiving.
That's your
is.
argument in opposition to the single document rule. I understand that. But let's assume it's in place, all right? So then what are you left with? You're left with time, right? That's not covered by the single document rule. The requirement for, in this case, for the approximate time is not there. It's not met. Even if you apply the single document rule, Am I correct about that?
Yes.
All right. If I'm correct about that, then if I understand your argument correctly, that the only way you could get around that is to say, is it an element of the crime? But of course, the statute here defines that, not the criminal or the penal law statute. So that's the problem. Do I have your argument correct?
Yes, but the Constitution also mandates that the waiver be evidenced by a written instrument signed by the defendant. And if we start to parse out time, date, and place...
Usually what happens, you guys have more experience than probably most of us on seeing these, but, well, at least some of us. But usually they'll say from sundown to sunset, or for a 24-hour period, or during all times on such and such dates. That would meet the requirement then, wouldn't it?
It would.
Yes, and it'd be upon information and belief. So it's not an onerous requirement to really meet. The question is whether or not, like Judge Stein says, is it jurisdictional? Does it throw it out entirely?
Yes, and the people are requesting situational expedience on the backs of defendants, Your Honor.
Thank you, counsel. Counsel?
Thank you. Shirley Gorman with the Genesee County DA's office. To start with the last issue, as the court knows, it's the people's position that the jurisdictional requirement is defined by the Constitution, as this court indicated in Myers, and that time, as the judge indicated, if it can't be knowable, cannot be jurisdictional. The indictment does not require a time. So how can the requirement that it be in the waiver of indictment...
But you would agree if we're down to the question of the time, this is not an onerous requirement. Just like I said, you can say at all times on such and such date. You could say on all times for a 2-week period. So that's an approximate time. So as a matter of fact, any date that you made reference to could be the approximate time if you equated the two. I've seen them written that way. That's why I'm asking, Ms. Gorman. Yeah.
And obviously, because it is time of day, not date.
Here's my point, though. If it's such an easy requirement, then why wouldn't it be? It's not hinging on a particular element of a crime. Why wouldn't it be there if it's required?
Why would it be?
Why wouldn't it be there if it's required?
Could it be there? Of course. It could be there. But the question is whether...
Just what Judge Stein said. Is it jurisdictional?
Right. An attorney's failure to raise it becomes the issue because it's not preserved.
Right.
It can only then be addressed by an appellate court if it's jurisdictional. So in these cases, time is not an element of the crime. So obviously that might be different in a case where an element of the crime does require a given time. Now, with respect to the waiver of appeal, this court held in Bryant that a waiver of appeal where a judge said no review at all will occur was appropriate. That's clearly not true because in every case there could be review. The only issue reviewed could be, was the waiver of appeal valid? But inaccuracies that go to leading a defendant astray about whether he can appeal. If a court misrepresents and tells a defendant, you will be able to appeal this issue, he relies on that in signing a waiver of appeal and then finds out during his appeal that's not an issue he can appeal because it was waived with his waiver of appeal, then clearly there's tremendous prejudice to a defendant. In a situation like this, as courts are holding, when it's overbroad, enforce the enforceable. You have defendants who...
What about the problem that when you tell a defendant you can't hire a lawyer, we won't appoint a lawyer for you, you can't even file anything on your own, that there are some number of people who are going to say, I'm not going to appeal. I'm not going to try to appeal because the judge already told me I can't have a lawyer and I can't do it on my own.
Well,
Isn't there sort of a chilling effect from overbroad, as you would find with speech in a way, from overbroad waivers?
Again, there are attorneys there who know to the contrary.
Of course, that's not their job.
And it is a situation where it's an attempt to avoid appeals by people who are forfeiting the issues that are waivable. And by being explicit, if a defendant is prepared to waive more than necessary, then...
Yeah, but it's one thing to say you're waiving particular kinds of claims and arguments and grounds, and it's another thing to say nobody's going to help you to figure that out. With Judge Wilson's point, right?
And
we might have some way of rationally saying that what you're arguing as this overbroad, just enforce what is actually enforceable under the law, is very different from basically telling someone you're out in the cold, you're on your own.
And the explanation in the written waiver, clearly in the oral waiver, the judge said you won't have these situations, never talked about the exclusions. Whereas in the written waiver, the exclusions are included. It says, it lists everything the judge said you're giving up, and then it says, I waive my right to appeal.
So this
with
is kind
the
of like the
exclusion
same
on.
situation that we had before, except opposite. Here, the written waiver may have been all right, but the oral waiver seemed to have more defects. So should we treat them differently? As a policy matter, should we have the judge giving active misinformation to be a different matter than the DA making errors on its written waiver? Is there a difference between those?
I think you look at both together.
Right.
And if one is accurate,
Well, wouldn't we judge them by the role of the person in the courtroom and what their particular job is? And a judge's job is different from the DA's job.
and clearly, because these waivers are signed in the courtroom, it is in effect the judge's waiver.
So let
no
me
matter
follow
who-
through on that. Then if that's the case, and it's coming from a judge, then doesn't that affect the knowing element of the KVI, knowledge, voluntary, and intelligent, with knowledge and voluntariness and intelligence? Doesn't it affect at least the first prong and then necessarily everything else? And you see, the reason I ask is because it seems in this situation where we could end up with a case similar to Santiago in the first department, where everything is out, or some different remedy that parses it and say, well, as long as they didn't actively tell you wrong rights, then you're probably okay. You see the difference?
I do, and I would point out that with respect to the judge's verbal colloquy, the defendant is asked, did you have time to talk to your attorney about this? And if there were any confusion, a defendant at that point would say no, or, but now I have questions from what you've told me. And of course, these waivers are used routinely, so attorneys have those waivers. It's not like they walk in the
Well,
courtroom.
that's true with the written waivers. I don't know if that's true with the oral waivers that the judge gives. They don't have those in writing ahead of time, unless the court sticks with the model colloquy, which didn't happen in this case.
Right.
Right.
No, and I'm not sure when the model colloquy was drafted.
So you've been doing this a while, and you've seen a lot of these things. Let's say we say that this whole waiver has to get thrown out. You've done a lot of appeals. How do you think it will affect the appeal practice itself?
Realistically, it will involve writing a brief on one issue instead of two, because we still have to write a brief on the issue which underlies
The
the
underlying
argument.
merits issue.
And the court,
The reason I ask is I just wanted to make sure that it wasn't going to be overwhelming or the world wasn't going to collapse. It's good for us to know that in terms of the courts itself.
but I think that everybody wants finality.
Sure.
Defendants should want finality. They should not be walking out of the room thinking that they've waived appeal, it's over, and then they spend 2 or 3 years waiting for the real end.
Yeah, except you
And-
yourself said it's never over, right?
I'm sorry?
You've actually said at the beginning, there are always issues
There
that
are
can be
issues.
appealed, so it's not, I understand the aspiration for finality, but in practice, the reality is that there are these non-waivable grounds that a defendant may seek to raise on appeal.
But
And-
isn't the reality that if all of these are thrown out completely, it's not just the non-waivable grounds that will survive, it will be otherwise waivable grounds that will survive? So while it may, for you, affect how many issues you brief, the reality is that it could result in significantly more reversals.
It will result.
Assuming error below.
I'm
You got
sorry.
to have an error to reverse on.
Well, it could be harsh and excessive. I mean, that.
It could be what, I'm sorry?
Harsh and excessive. Because if there are issues that are typically waivable that still get to the appellate division, it is a question about the sentence. And so, although everybody thought they had an agreement, all of a sudden, the agreement is vitiated because the appellate division decides the sentence was harsh.
Let me ask about.
As I understood your briefing, you seem to draw some distinction between waivable or non-waivable rights and issues that really go to the characterization of what the right to appeal is. And I'm referring particularly to references to 440 motions and habeas corpus. Do you see a distinction there? Is that?
I see if, again, a court misleads a defendant about having a right to appeal, which he doesn't have. But when there are errors involving not adequately explaining to him what rights he will have when he thinks he's losing them, that I don't see.
So you would lump that in with all the other things that we've been talking about
Yes.
here?
Yes.
Can I
And
just
I would point out, because the Green case is a situation where there was a waiver of the right to appeal, left the room, found out the PRS had to be longer, came back in the room, and we are left with, does the defendant have to know the maximum sentence before the words, "I waive my right to appeal," are said? Is this part of the plea bargain? Is this part of the colloquy about knowing, intelligent, and voluntary plea, this condition of the plea that the waiver of appeal be waived? So that only if this court finds that the sentence must be explained before the waiver of appeal is elicited, would that be a problem in Green? Because she came back in and said, I understand that PRS has to be 2 years longer, but I want the plea to sustain.
Can I just go back to what your practice is when there's an appeal waiver? Do you, because at least my impression is, not for you, but generally, that when I see the appellate division briefs and there's an appeal waiver, they will say, the district attorney will say, there's a waiver here, but then we'll also brief the merits, almost invariably. And then what I see the appellate divisions doing is sometimes standing on the waiver only, but more frequently doing one or the other, either saying the waiver is not valid and then reaching the merits, or saying we're not going to deal with whether the waiver is valid, even if it is invalid, and then they dispose of it on the merits. Is my impression right, and what do you do? Do you brief both when there's a waiver? Do you brief the merits and the waiver?
You have to brief both the waiver issue and the underlying issue that's argued, usually harsh and excessive, because you can't assume the court, because we have no way of knowing for sure what's valid as a waiver of appeal, you also have to argue the other issue. And of course, there are times when arguing that other issue means there's oral argument.
So if you don't know, how does the defendant know?
I'm sorry?
If you don't know what's a valid waiver of appeal, how is the defendant supposed to know?
Well, I think
I don't mean defense counsel, I mean the defendant.
No, I understand. And the problem is that no matter a waiver of appeal that says the only issues which survive are these four is now being challenged because there are other issues. So only is wrong, therefore we should be allowed to find the waivers invalid. There's always another argument.
Specific to the Green case, what is the effect of our holding in Johnson? And how does that play into the analysis?
If the appeal waiver were invalid in that case, the court would have to remit to the appellate division to deal with the merits of the harsh and excessive argument, because they did not give an advisory opinion in effect.
And it would probably have been easier for the appellate division to deal with that than have to worry about the waiver. I mean, pretty straightforward.
Right. Okay, thank you.
Thank you. Counsel?
Thank you. First, I just want to say that the misstatements by the court either knew or should have known those were wrong. And that's due to the fact that when, for instance, the court says, oh, you can't get counsel, but that's the court that assigns counsel, in this case, us. And that was happening for years. These judges were both on the bench for a long time, and time after time, they're saying, no, you can't get counsel, and then giving the cases to my office. So I think having courts say things that are wrong and that they should know are wrong going to Muniz, just as a matter of public policy, can not be a good thing, and I don't think it's the right way to go.
If you were invalidating this waiver and trying to distinguish this from some of our waiver cases, would it make more sense to you to do it based on the misinformation about the right to counsel, or the fact that it was included in the waiver that he can't bring a 440? And why?
In terms of, if I understand your question here, in terms of, like, basically which is worse?
I suppose that's one way to rephrase the question. I'm just trying to figure out what's a more workable rationale.
Well, I think that saying that she could not have counsel is worse, because then some of these people might not ask for counsel, and then who knows, there'll be no one to look at the cases and see even if there could be a 440.
So how is that not inconsistent with what we said in Ramos, though?
Whereas the language was overbroad there? Is that what you?
Well, yeah, it talked about, yeah, no, I'm sorry. It actually mentioned it as a right of appeal, but then said, yes, that I'm giving up those rights.
Right.
So, yeah.
Right. In Ramos, it's, I think if I remember right, it's just that it was overbroad, where this is not.
It specifically mentioned those rights to assign counsel and poor person relief. So,
Right.
And that's what, if I understand correctly, Judge Feynman's question and what you're talking about is that's the most serious, but we've said it's okay.
Well, I think here, I do think that that's a issue, but also that goes to whether it's knowing, intelligent, or voluntary. And I think just that there's this constant barrage of statements that are false.
What other statements are false besides those?
Well, you have, for instance, no other review by any court.
But we've said that's okay before. We've said in one of our cases that where you say you're not going to get this reviewed by any other, no other court will look at this. We've said that's okay.
Right, but then in the same part, the judge says, okay, well, this waiver only goes to some issues. So he says some issues and then says no review. So both can't be true. It's not just that it's overbroad. It's that it's contradictory because they're logically inconsistent. The defendant would have to say something like, okay, I understand that I retain some of my rights, but I also at the same time understand I don't retain any of my rights. They can't think both are true, which goes to the fact that the waiver isn't made knowingly and intelligently,
But
because
it seems what the theory of our prior cases has been, in the worst case scenario of that problem, you thought you waived more than you really did. It's not like you thought you waived less. I may only have these limited rights, or I may have no rights. We've said, well, you actually do have the limited rights, but even if you thought you were waiving everything, you'll still have those. So I don't understand how you distinguish this case based on those factors.
well, to that point, going back to something that Judge Wilson has said, we only can get these cases because our clients want to file an appeal. So if people were to actually think, okay, can't get counsel, can't file a brief, who knows what would happen? There may be an issue with merit, and no one would ever get a chance to take a look at it.
I think that is the main point here, it seems to me, and I think your colleague made that point very clearly, that this is really a deterrent rule.
Yes.
Because your clients clearly understood, or their lawyers understood, and they're here and they're challenging various things.
Right.
But this would be a deterrent rule for other defendants. And I think
Right.
that's the legitimate
Yeah.
argument.
Right. It would, and going back to what I started with, the court should have known that what he was telling Ms. Green wasn't true. So it's not only a deterrent, it's one that the court knows is wrong. So why use a deterrent that they know isn't true as a matter of public policy?
No, I mean,
don't
our
think-
rule would be a deterrent. I'm sorry, I was probably being
sorry.
confusing. No, I've already articulated it. But I mean, our rule saying this is invalid really would act more as a deterrent from this practice
Right.
than it would a statement that in this particular case, this defendant didn't understand what they were waiving.
Yes, that's true, but I also think in here there isn't enough on the record to know that she actually understood either, because of just all of the contradictory statements, I think prevent anyone from logically understanding due to the fact that they don't know which ones are true and which ones are not true.
Your last point, or just before this point, I'm sorry, was that there's something particularly troubling when a judge, if they don't know, but should obviously know,
Yeah.
because it's so obviously incorrect, should not confirm or perhaps create greater confusion by repeating the error
Right.
in the waiver.
Yes.
That is a different case from just an overbroad waiver.
Yes. That is, I think, quite a bit different.
Thank you, counsel.
Thanks.
Thank you, counsel.
This court should require the people to comply with the statute 195.20 rather than steering around it. And in accordance with the Constitution, the CPL and all of its established precedent rule that Mr. Lang's waiver of indictment was jurisdictionally defective.
Thank you.